whenever you're ready.
Yep, there it is.
Thank you so much.
No problem.
Officer Day, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Good morning, Counsel.
Morning, Your Honor.
I apologize. We got started a little late. We had an IT issue.
That's okay. No problem.
Let's get your case called and get you started. This is file 22-185-681, Citibank versus Mitchell Wade. This is the date and time set for a motion for entry of default judgment. Could I have your appearance?
Morning, Your Honor. It is Craig Fay, P 81401 on behalf of Plaintiff Citibank.
All right. We were last together on this file on November 3rd. At this time, the court adjourned the matter to today's date and indicated there'll be no further adjournments on that motion for default judgment. Counsel, let's hear your motion.
Sure, Your Honor. We just as a premise, we did send out the consent judgment twice after the last appearance. We haven't received it back. So it looks like on this particular matter, defendant was personally served. A pretrial was scheduled there after the defendant filed an answer. Pretrial was scheduled for July 7th. To which the defendant failed to appear and a default was entered. And at that time, Your Honor indicated that if we filed a motion for default judgment based on defendant's failure to appear, we did attach Exhibit A, it's copies of detailed account statement showing that showing the balance, the running balance. As the defendant failed to appear again today, we're requesting the court to enter a default judgment based on defendant failure to appear and to respond to this motion for the complaint balance plus court costs less any payments received to date. We have received $750 from the defendant pursuant to the verbal agreement that we had. We just have not received the signed consent judgment at this time.
All right, then, counsel, what I'm going to do is I'm going to grant your motion for default judgment. I look forward to your default judgment in the mail.
Perfect. Thank you, Your Honor.
Thank you, sir. Appreciate you. Sorry about the delay.
No worries. Thank you, Your Honor.
Thank you. Good morning, counsel.
Good morning, Your Honor.
Sorry about the delay. We had an IT issue this morning. Mr.
Yes.
Webster, are you there?
I can hear you guys, but I can't see you.
Turn on your video.
Gotcha.
We are on the record calling file number 22-187-308, Automobile Club of Michigan versus Bernard Webster. This is the date and time for a motion for summary disposition under MCR 2.116C7 filed by the defendant Webster. Appearances.
Good morning, Your Honor. Denise Baker, P 53670, appearing on behalf of plaintiff.
What is your name, sir?
Bernard Webster.
Your motion, sir. Please proceed.
The motion for dismissal for violation of statute. 3 years has passed that they filed this lawsuit against me.
3 years has passed, sir? You mean
Yes,
That's the date of the accident.
correct.
And as I understood your pleading, you were served with summons and complaint almost 6 years after your accident. Is that correct?
Yes, sir.
Let me hear from counsel for the other side.
Thank you, Your Honor. The motor vehicle accident occurred on August 8th of 2016. The basis for defendant's motion is a violation of the statute of limitations. And I think the confusion came in here with the statute that was cited by the court and citizens. Under 600.5807, it actually should be subsection 9. The statute was updated since the court decision in citizens. The period of limitations is 6 years under a breach of contract action. As stated in our brief, the courts have specifically held, and the court cases are Citizens Insurance Company v. Buck and Transamerica Insurance Company versus Blue Cross Blue Shield, that subrogation actions arising under the no-fault regime are subject to the 6-year statute of limitations. Again, the motor vehicle accident was August 8th of 2016, and the summons and complaint was filed on May 18th of 2022, which is within the 6-year statute of limitations. Under MCL 500.3177, a no-fault insurer is entitled to recover personal protection insurance benefits from an uninsured motorist that it was contractually obligated to pay. And the courts have held, again, specifically that the 6-year statute of limitations applies, and therefore defendant's motion must be denied.
Is there anything else you want to add, Mr. Webster?
Yes, due to the new information, I like more time to look into the new MCL that they came up with. I was responding to the MCL that they put in their response.
Did you read their brief?
No, I didn't.
Indeed. Court's prepared to rule in this matter. The brief, which was filed back on October 31st of 2022, so you've had plenty of time to read it, sir, provides in pertinent part at page 2. The court in Citizens held that expressly the subrogation actions arising under the No Fault Act are subject to the 6-year limitation of MCLA 600.5807A, citing Transamerica Insurance versus Blue Cross Blue Shield 440 mission 4894. For the reasons set forth in the motion, the response to the motion filed by plaintiff, defendant's motion for summary disposition is denied. We'll set this matter for pretrial. Your written discovery is now open. Your pretrial date with me will be January 11th at 10 o'clock in the morning. Sir, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court.
Can I ask you something, sir?
Sir?
With the other defendant purchasing this vehicle from me, I don't understand why I'm being held for this at this point either. He was purchasing the vehicle.
Sir, I cannot give you legal advice.
Okay.
I'm responding to the motion that you filed, the response that was filed by plaintiff. We're going to get started on our file. If you want to file some other motion, sir, you have an absolute right to do that. But that's not for me, and I cannot give you legal advice. January 11th, 2023 at 10 o'clock will be our next meeting. The written discovery is now open. I will send out 2 orders today. There'll be an order denying the motion for summary disposition filed on behalf of defendant Webster for the reasons set forth on the record, and there'll be notice of your pretrial January 11th at 10 o'clock, and your written discovery is now open. Thank you all for coming in.
Your Honor, may we schedule a motion for summary disposition for the January 11th date as well?
Let's see where we are on that, because I don't know if there's going to be any discovery done. That's why I'm only opening written discovery today.
All right, thank you so much.
Thank you for coming in.
All right.
Hello?
Mr. Arnold,
Good morning.
let's see who's here.
Yes, can you hear me?
Yes, I
John?
can. I'm trying to see if I can get the other side in here.
Okay.
Judge, I'm in.
What file are you here on, counsel?
Thank you, Judge. Velocity Investments versus Renee Neal.
Oh, I got you on the wrong file. Okay, let me see. You're here for whom?
I'm here for the defendant Renee Neal on behalf of Charles Hemming Law Firm.
That ain't us.
All right, Mr. Johnson, Mr. Arnold, I got you in the wrong place. I'll put you back in the waiting room. I'll come back for you.
All right, thank you.
Just stay there.
Uh,
And your name, you're here for Velocity Investments?
I'm here for the defendant Renee Neal.
Yeah. Got it.
For Charles Hemming.
Mr. Johnson,
Good morning, Your Honor.
good morning. Gentlemen, I gotta apologize to you. We got started late today. We had an IT issue. So let me get you moving as fast as I can. This is file number 22-195-652. Velocity Investments versus Renee Neal. Date and time for pretrial, your appearance.
Good morning, Your Honor. Brad Johnson, P75416, on behalf of the plaintiff.
Your Honor, Mark Sobel, P41764 on behalf of defendant Renee Neal and the law firm of Charles Hemming.
Gentlemen, where are we on our written discovery here?
Your Honor, sent out plaintiff's interrogatories. They're actually due tomorrow, the 28 days. I did grant a professional courtesy. They requested they be due December 16th. I said that was fine. Once I get those back, we're in dissettlement negotiations. Once I get the answers back, I'll either file a motion for summary or settle the case. That's
Right.
my plan.
Okay, gentlemen, we'll give you a new date, get you out of here. Your next
Okay.
date with me will be January 11th at 10 o'clock. Does that work for everybody?
Is that a settlement conference?
It's a pretrial, sir, like today.
Pretrial? That works, Your Honor.
Works for me too, Your Honor.
All right,
At 11 a.m.
no, 10 o'clock
I'm sorry, 10 o'clock. I'm sorry, Your Honor.
on the 11th.
On the 11th. Okay.
It's all right.
You're awake today. I'm not. Thank you.
I'm not having a great day today. Your written discovery will remain open. Is there anything else, gentlemen, we can accomplish today?
Not this time, Your Honor.
No, Your Honor. Thank you.
Okay. Then we'll
Thank
see
you.
you then, January 11th at 10 o'clock. And Merry Christmas to you both.
And happy holiday and healthy new year. Yeah.
Thank you, gentlemen. We're
Thank
off.
you.
the break.
Appreciate it.
Thank you.
Mr. Zelinski, good morning.
Morning, Your Honor.
What file brings you here today?
010.
Okay, I have Mr. Arnold.
Okay.
All right. We are on the record. This is file number 22193010, American Lending and Finance versus Edward Arnold. Appearances.
Good
Yeah.
morning, Your Honor. Robert Zelinski on behalf of plaintiff P69250.
And your name, sir.
Edward Arnold.
Mr. Arnold, is it your intention to represent yourself in this matter?
No, I couldn't, I tried to I couldn't afford a lawyer, so I've been
Okay.
trying.
You have an absolute constitutional right to represent yourself. What you do not have is a right to your own set of rules, civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind the lawyer will be binding on you. You understand that?
Yeah,
All right. Well, first of all, gentlemen, we have a procedural matter to take care of. There is a co-defendant, Chantil Sierra Sankey. Ms. Sankey was personally served and has failed to file an answer. And a default judgment has been submitted on behalf of plaintiff against her. Mr. Zelinski, we will be entering that default judgment today.
Okay.
So we will proceed as to Mr. Arnold. What I'm going to do, gentlemen, is I'm going to open your written discovery. I'm going to give you a return date. Your return date with me will be January 11th at 10 o'clock. Does that work for everybody?
Yes, Your Honor.
That work for you, sir?
yes,
Okay, the written discovery is now open. We'll send you guys out a notice. Mrs. Zelinski, you'll get a copy of the default judgment in regard to the co-defendant.
Okay. Could I say one thing to the defendant, Judge?
Sir,
Mr. Arnold, if you want to give me a call after the hearing or any time to discuss the case, you can do that.
why don't I do this? Why don't I put you guys into a chat room?
Okay, that'd be great,
And
Judge.
then you guys can do that. I will talk to you unless you could settle the case. Come back to me. If you do not settle the case, I'll talk to you again January 11th at 10 o'clock.
All right, great, Judge. Thanks.
Record. Now, let me see if I can get the tech to work today. I'm having a problem with my technology, and I want to apologize to both of you. We got started late because we were having IT issues today. I'm sorry about that. I don't like to waste people's time.
yes.
4. Yeah, okay, there we go. All right.
All right, if you can hit join, Mr. Arnold.
Hit join, Mr. Arnold. Okay, he's there. Hello? Hello?
Yes,
What is your name?
Kevin Green.
Kevin Green? Mr.
Yes.
Chisholm? All right, let's get started.
Okay.
I'm waiting for the other guy's audio to link up, Mr. Green. Hang on.
Okay.
All right, Mr. Green, you there now?
Yes.
Mr. Chisholm, can you hear me? Still no audio, Mr. Chisholm. There we go. Okay, you hear me now, Mr. Chisholm?
I do, Judge. Judge, I'm on my hearing in Mackinac County picked up here at 10:30, so I'm just trying to wrap that up, and I've got about probably 90 seconds left in that.
All right, I'll put you back and then come back.
I appreciate that, Your Honor. Thank you very much.
Mr. Green, I'm gonna come back to you. Let counsel finish his other hearing. I'll be back for you just a moment. Good morning, counsel.
Good morning. How are you, sir?
Sorry about the delay. We had some IT issues this morning.
Oh, that's all right.
Let's call your file and get you out of here. This is 22-243-334, Blake Carlton versus Anthony Balsamo. By a notice dated October 31st, 2022, this matter set for pretrial today, December 1st at 10 o'clock. It's now after 10:30. I note for the record that this matter was initially filed in the Small Claims Division and was removed to General Civil. Sir, could I have your appearance, please?
Ed Maciejewski on behalf of Carlton Blake.
Bar number?
What am I? P84240.
That's why
Sometimes I forget.
you spend enough time and money to get the number. You ought to remember.
I know.
All right, this is the date and time set for a pretrial in this matter. The defendant has appeared by counsel. Plaintiff has failed to appear. No good cause of that failure having been shown. The matter is dismissed without prejudice. Sir, we'll send you out an order today.
I appreciate it. Thank you, Your Honor.
Be safe.
You too.
Off the record.
No,
You ready for me?
I am, Your Honor. I'm so sorry. I appreciate your patience with me there, Judge.
Let me-
Yes, I am. I'm all
Let
done.
me get Mr. Green and we can get started.
Okay, thank you, Judge.
Mr. Green,
Yes,
you there?
yes,
All right, let's get started. We are on the record,
Okay.
file number 22-190626, Reliable Auto Finance versus Kevin Green, date and time for pretrial appearances, gentlemen.
Good afternoon, or good morning, Your Honor. Jeremy Chisholm, P74670. I'm the attorney of record for the plaintiff.
And your name, sir?
Kevin Green.
All right. This is our third pretrial on this matter. Is our written discovery completed?
Judge, the plaintiff has submitted requests for admissions to the defendant. We have not received them back. I do believe that we have a motion that has been filed. I don't know that the court has put it on the calendar yet. I am not aware of it. If it's happened, maybe it's in our mail room or something like that. But I do know that we filed the motion. I've done it, and a check was issued and everything. So
I have your motion for summary disposition.
you do. Okay, thank you.
Because I want to make sure the parties were done with written discovery. Are you done
Okay.
with your written discovery, Mr. Chisholm?
From our side, yes, Your Honor, we are.
Mr. Green, are you done with your written discovery?
Could you repeat that?
Sir, I'm asking you if you are done with your written discovery. This is our third pretrial now.
I got what I need to say.
Okay, then written discovery is closed. And what I will do is I will calendar the motion for summary disposition filed on behalf of the plaintiff. The motion will be heard on January 11th at 10 o'clock. We'll send you gentlemen out a notice today, and thank you both for your patience. I have to apologize for our late start. We had a problem with the IT guy today. I don't know what happened. I had to get the IT guy in for this.
Excuse me, when would I get a chance to talk?
Sir, what do you want to say?
Okay, I tried to accommodate Reliable Auto's attorney with paperwork showing reasons for my actions. The attorney stated he could not make out the captions, so he told me to send them to a Jennifer. I did, and she stated the same. Could not make out the captions, so I sent by mail. Enclosed was the original contract for $11,688. The change order for $18,249. Now that's not good enough, and they want more money.
I didn't hear what you said, sir. After the numbers, your voice faded out.
Now they want more money. Now they want more money.
Yes. Is there anything else you want to say? Because there's a motion for summary disposition, and you have an opportunity to file an answer to that. Have you seen the motion for summary disposition filed on behalf of the plaintiff, sir?
Could you repeat that, please?
Yes, sir. I'm asking you if you have seen the motion for summary disposition filed by the plaintiff.
No.
All right, here's what we're going to do. I'm going to close your written discovery. I'm going to set the motion for summary disposition for January the 11th at 10 o'clock. Mr. Chisholm, you will serve another copy of your motion for summary disposition and file a copy of the proof of service today.
Will do, Judge.
All right, gentlemen, if you want to file an answer.
Your Honor, can I request, I want to confirm that we have Mr. Green's address, because as you see, I'm sure in the court file, we've already included a proof of service, and we have sent this to. So I want to make sure I've got the right address for Mr. Green, if he could confirm that address.
Mr. Green, are you still on a Burwood Street address?
Yes.
Okay, you got it.
Okay, thank you, Your Honor.
All you need to do, Mr. Chisholm, is do not send me another copy of your motion for summary disposition. Just send me a copy of proof of service of that motion on Mr. Green at that Burwood address.
Thank you. Your Honor, by mail, or does the court?
Mail is fine.
Is the good mail is fine?
I don't need it until we're ready to hear the motion.
Sounds good. Thank you, Judge.
Green, if you want to file an
Yes.
answer to the motion, you have an absolute right to do that. You must file and serve that answer no later than 7 days before that January 11th hearing date. We'll send you guys calendaring the motion for summary disposition. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
Excuse me. How do I do that?
How do I do what? File an answer?
File. Yes.
Sir, you filed it at the 36th District Court, like you filed your answer, and you send a copy of whatever you send. You file a copy with the court. You file a copy and send a copy to the court with a proof of service. You serve Mr. Green, Mr. Chisholm, with that same document, whatever it is, and send file proof of service of that. You understand,
So I
sir?
can call 30, so I can call 36th District and they'll tell me all of that?
No, sir. We do not give legal advice. I'm telling you what you have to do. You either can do it or you don't. You send a written copy of your answer to the court. You send a copy of that identical document to Mr. Chisholm by first-class mail, postage prepaid, and you file a proof of service with the court that you sent your answer to Mr. Chisholm. Thank you, gentlemen.
Okay.
January 11th, 10 o'clock. We're
Thank
off
you,
the
Your
record.
Honor.
Thank you both for coming in. Thank you for your patience.
Thank you, Judge. Have a great day.
Representatives in the Canadian Coalition for Firearm Rights forum, and they'll say it's actually political government that's been done last year. When they all eyes were on public safety minister Marco Mendocino's testimony to the Mullen Party, the Liberals found enough votes at the Commons Public Safety Committee to amend C-21. That's the bill that details the government's incoming ban on what it calls assault weapons. So its criteria now were covered. Many more radicals only used for hunting than what the government originally proposed. The firearms that were predicted weapons. Nobody got from all of our legislative section. Representative said yesterday that the act needed to do in line with those details like the original list, but maintained that it's the federal government stuff to set the law on what guns are legal. You know, it's what it is. Any parent across the country can apply for the new dental benefit for children. Named as low-income families primarily with the Canada Revenue Agency and the program. ADP was for the dental benefit along with expanded sick day guarantees, part of an agreement with the minority rules on legislation and confidence votes. Ontario's legal regulators in a provision saying they plan for approval. It's deciding whether to open the process as family courts to paralegals. The full broadband by being financially exhausted. That found Nova Harvey ended up self-representing in her divorce case. The Aurora, Ontario woman started the process with a lawyer but couldn't afford to pay. And she made too much money to qualify for legal aid. So really no member was very tough and funding share that. Harvey is one of the growing number of Canadians going it alone. Nearly 60% of people across the country are self-representing in family court. And that figure is closer to 80% in urban centers like Toronto, according to Julie McFarland. She founded the National Self-Represented Litigants Project after her research shows most people who appear in court without a lawyer can't afford one. We need change now. To fill the gap, the law society of Ontario has been trying to develop a family law license for paralegals for years. Maybe the regulator will work on a version to allow paralegals to help navigate procedures and complete applications for simple, uncontested divorces. Mexico broadband in Toronto. The family is facing more accusations of racism in the wake of an incident at a Buckingham Palace royal reception. Happy to get off that story. After an interrogation, this is how Lower Bolani fell at a Buckingham Palace reception after speaking with Cindy Hussey, Prince William's godmother. And she takes her hand and moves it out of the way so that she can see my name badge. That was a surprise. The founder of Sister State's domestic abuse charity said Puffy approached her before asking where she was from. Puffy then replied, "No, what part of Africa are you from?" There was two of us just standing there, completely stunned. Nanu Reed heard it all, since with the British Women's Equality Party. They never feel like something wrong with them. That's the long year. Puffy was the queen's lady in waiting for about 6 decades. The palace called her comment unacceptable. The 83-year-old has apologized and stepped aside. Prince William said in a statement that racism has no place in society. At the World Opera Institute in London. Tom Allen hosts About Time. The name has players of but mostly in this education that the music programs program is the music that has been deemed by time to be that or your time. About Time, 3 hours of timeless music. Weekdays starting at 12:30 Newfoundland on CBC Music and the CBC Listen app. Only the best classical music. Tempo on CBC Music. Hi there, I'm Julie as well. Welcome to Sunset Dinner. Today it's all about musical number 12 songs. First of December. So happy that it was a thing. It's like in your own music recipe.
Hello? Hello? Hello?
Yes, hello.
What is your name?
Jordan Irby.
All right, Mr. Irby, I don't have the other side as of yet, so I'll put you back in the waiting room.
Okay.
We are on the record calling file number 22-190396. Jordan Irby versus Keys Auto Sales. This matter by notice is set for hearing today at 11 o'clock on the plaintiff's motion for entry of default judgment. What is your name, sir?
Jordan Irby.
Mr. Irby, have you received a copy of the defendant's motion to set aside the default?
No,
It was sent out to you on about November 7th.
November 7th. I don't think I received a copy.
Okay, then what I'm gonna have to do, because they filed that motion, I'm gonna adjourn your motion and set their motions. We'll hear them both on the same day. The next day will be January the 11th, at 11 o'clock. We will hear both your motion for entry of default judgment and the defendant's motion to set aside the default.
Okay,
We'll send it out to you today. If you want to file an answer to the motion to set aside the default, you should file and serve it. Send a copy to the court, serve a copy on the other side as soon as possible. Thank you for coming in.
okay, thanks.
Yes, sir. We're off the record.